So in previous lessons, we've been discussing the nature of the leasehold estate. Now, this lesson is going to spend a little bit of time talking about the major characteristics of the lease. Now, this will be useful to keep in mind for the duration of our lessons when we talk about the lease, especially when we talk about the different kinds of leases, given the fact that there are some discrepancies between what is considered to be the essential characteristics of the lease as established in the case of Street and Mountford on the one hand, versus some of the different types of leases which may or may not fit nice and neatly into the mold of these characteristics on the other. So that's something that to keep in mind when we go through this lesson. But fundamentally, as a spoiler alert, we're going to be talking about the case of Street and Mountford, the case of Street and Mountford giving us an indication of what are the essential characteristics of a lease, what is required for a leasehold to exist. In the previous lesson, we finished by noting, referencing the case of Brunton versus London and Quadrant Housing Trust, that an intention to create something that isn't a lease, i.e. to create something like a license, does not actually necessarily preclude an agreement from being a leasehold agreement. Now, this is something of an interesting point. It's something of a controversial point, because what this case essentially involved was the giving away of something that that person didn't have, which is obviously a basic tenement of law, that you can't give that which you do not own. But nevertheless, this is one of the cases that illustrates the point about leases, mainly the point about something being a lease, whether or not you intended it to be a lease or not. The intention of the parties, so long as it looks like a lease and it sounds like a lease and it walks like a lease, then it will be a lease. That's the kind of point that is made. So the intention to create a lease does not necessarily preclude an agreement from being a leasehold agreement. The reason for this is because so long as it has the certain and distinct characteristics which are necessary for the existence of a lease, then it can become one, or it can be one, even if, like I said, the intention does not necessarily suggest that it is. And so we can draw on the case from Street and Mountford to identify what these various different characteristics actually are. So what are the characteristics and the requirements for the establishment of a leasehold estate? So the case of Street and Mountford from 1985 is an illustrative authority on this question. It gives us the indication of what or at least what are the key characteristics of a leasehold. The case specifically, in terms of the facts, involved Street, who had a written agreement with Mountford, which gave Mountford exclusive occupation of Street's house. The agreement itself was actually intended to be a license, and all the deliberate wording suggested as much. So it was considered to be a license agreement. It was expressly clear that it was a license and not a lease. Okay, so think back to the previous case and think back to our previous discussion about whether or not intention actually necessarily matters, or whether or not it necessarily is a good indication as to whether or not something is or isn't a leasehold. When a dispute arose whereby Street sought to terminate the agreement, it was argued that in fact it wasn't a license, and in reality it was a lease, because as a result of which, if it was found to have been a lease, then Mountford would have certain rights under the statutory requirements of the Rent Act from 1977. So essentially, if you have a lease rather than a license, then you have certain other rights which exist over your particular occupation of a property, rather than necessarily that you have more rights as a leasehold, owing to the proprietary nature of the right, rather than the just simple non-proprietary nature of a license. They argued that it was a lease, not necessarily owing to the fact that there was an intention to create a lease, but rather because it granted exclusive occupation of part of the property, namely of 2 rooms within the property. So they made the conclusion that essentially you may have called it a license, but in fact what you had created was, by all accounts, a lease, owing to the characteristics of it. And so when Street argued that the idea of exclusive occupation could still be a license if the parties intended it to be an agreement of such, the courts had to determine A, what were the characteristics of a lease, and then B, whether or not this actually fell into those characteristics, and therefore meant that there were certain statutory requirements that Street had to uphold. It was held that, by the House of Lords, the agreement was in fact a lease and not a license. So despite the fact that there was an intention to create a license, and this intention was expressly stated there throughout all of the agreements, all of the paperwork, for example, it still was nevertheless a lease. Lord Templeman outlined the basic characteristics of a lease in the judgment to this case, and they said that these are the following characteristics. Firstly, there has to be a certainty of term. This relates to the sort of temporal nature of the leasehold. Remember, the distinguishing feature between a leasehold and a freehold is the fact that with a freehold, you essentially have an indefinite amount of time for which you have exclusive possession of the property. Whereas when we talk about the leasehold, you have what is known as a, quote, slice of time. There's a certain duration, a certain period of time in which you have access to and exclusive possession over that particular property. So certainty of term is a key characteristic of a lease. The second is this idea of exclusive possession. Exclusive possession, of course, is something that distinguishes a lease from a license. So a license does not necessarily have this exclusive possession, exclusive occupation of the property, whereas a lease, owing to the proprietary nature of that interest, proprietary nature of that right, they do have exclusive occupation of said property. And then there's the final characteristic, which is the payment of rent. There has to be a payment of rent, which obviously is payable by some kind of value, often money, which obviously represents the payment of the leasehold. Now, the extent to which this is necessarily a requirement is questionable in today's law, because you could theoretically have a leasehold that does not have the payment of rent, or maybe has quite unusual and unexpected forms of rent payment. But for the most part, you will pay rent when you have a leasehold. But in terms of the absolute and the necessary requirements for a leasehold, you have to have the certainty of term. You have to have the exclusive occupation of the property. Let's begin then with certainty of term. Certainty of term simply requires that a lease have a fixed and knowable starting point, as well as a fixed duration in time. Now, if there is certainty of term, it doesn't actually matter if the parties fail to meet the end point. So if they decide instead to break the lease at an earlier point, because there are various different ways in which the termination of a lease can take place, which we will get to in future lessons, that's irrelevant. It doesn't mean there has to be an end goal that we have to reach in order for this to be a leasehold. All that it needs to be is that there has to be a distinct and clear starting point, often a date, and a distinct and clear duration in time. Now, given the fact that most lease agreements will have some kind of break clause for the parties, it means that it would not make sense for this duration of time to have elapsed in order for there to have been a leasehold in the first place. We will get to in future lessons time the nature of certainty of term and the ways in which leases seem to try and bend as much as possible the rule relating to the certainty of term when you talk about things like periodic tenancies. But for now, when you think about certainty of term, there will be a start date. Let's say I have a lease agreement I sign and it says that I'm going to start the agreement on the 1st of January 2024 and it's going to run for an entire year. It's going to run for 12 months. This would therefore mean that I know that there is a certain directly certain endpoint. This is, of course, the 31st of December 2024. That does not necessarily mean I move out on the 31st of December. I might break the lease earlier on, owing to a number of different reasons. I may agree to extend the lease, which often takes place, given the fact that landlords will often don't want to spend lots of time putting their property up for sale or up for rent, and having new agreements made, having people move in, move out, and all this kind of stuff, and doing certain renovations therein. They would prefer to just have their property making the money for as long as possible, for as much as possible. Equally as well, tenants probably, given the nature of their particular settings and circumstances, would probably prefer it if they had the ability to extend their lease if they so chose. So that is also an option for individuals who have leases, who rent, for example. The next idea is this idea of exclusive possession. Exclusive possession requires the ability to show that the parties, i.e. the lessees, are able to exclude all others from the property. Remember, when we think about exclusive occupation or exclusive possession, and when we think about the leasehold estate, it is a proprietary interest. It is, for all intents and purposes, as strong as a freehold interest. Okay, it is as strong as a freehold interest in terms of at any one time. The difference between a freehold and a leasehold is the certainty of term. It is the duration of time in which you actually have access to that property. You can exclude all others from the property if you are a lessee in a leasehold agreement. This also includes the landlord. You can exclude, theoretically, the landlord from your property as if you have exclusive occupation, which is, of course, a requirement for a lease. As I've mentioned earlier, this distinguishes a lease from a license, and the idea of certainty of term distinguishes a leasehold from a freehold. This is how we get these different types of exclusions. So the idea of payment of rent, as I mentioned, the third requirement in the Street and Mountford list, is a little bit more complex. So the case of Ashburn and Salt versus Arnold from 1989 actually rejected the view that this is a requirement for the existence of a lease. So whereas exclusive occupation and certainty of term are necessary in one way or another, there's obviously differences when we talk about the different kinds of leasehold agreements related to certainty of term, but nevertheless they are still required. The idea of payment of rent is a little bit more flexible. Ashburn and Salt and Arnold made that very, very clear. While not necessarily a requirement in the sense of the other two being representative requirements, i.e. necessary requirements, it is still nevertheless almost a de facto requirement, going to the fact that it is a very, very, very common feature of a leasehold. It is probably, there's not very many leases that don't have any kind of exchange of payment, whether that be a payment of rent through money, or whether it be a payment through other kinds of things like property or whatever, or anything really. That is still a very common feature of a lease, and so therefore represents a common characteristic of a lease that you might find in problem questions.